having the legal advice and the legal counsel to help you make those decisions, completing your documents, making sure you really truly understand the outcomes that you're creating. Just even going back to the beneficiary designation, somebody fills it out themselves, and if the custodial documents are saying per capita, they think, great, that's great, but that might not really be what they want. And so without somebody who has the professional background to describe what those things mean and what the outcome looks like, they're doing a disadvantage to their family if they try to do it themselves.
Welcome to the Healthy and Wealthy Retirement, where your certified retirement counselor, Mark Struthers, takes a holistic approach to retirement, going beyond finances and embracing holistic well-being. This YouTube channel will address not just the financial part of retirement, but also the social, the physical, and the emotional parts of retirement. Everything you need for healthier, a wealthier, and a happier retirement.
Welcome to the Healthy and Wealthy Retirement. My name is Mark Struthers. I am grateful you are here today. I don't think you'll be disappointed. We have a very special guest that is going to help us out with one of the most important but overlooked, even neglected parts of financial planning, and that is estate planning. Our guest today, Jenny Spalding, is an award-winning, sought-after public speaker on the topic. She was born and raised here in Minnesota, so she's one of us, so you can trust her more than people from other states. We all know that. She is a graduate of the University of St. Thomas and William Mitchell School of Law. She is admitted to the state of Minnesota, the United States District Court for the state of Minnesota, and the United States Supreme Court. She's a member of the Minnesota State Bar. She has over 20 years of legal experience, including that of being a criminal prosecutor for Eden Prairie, which, if we have time, I'm sure there's an interesting story about that transition. So I hope we have time to hear it. She works out of Victoria, Minnesota, a small town, although I think it might be considered an outer ring suburb as the Twin Cities, Minnesota, Minneapolis area grows. I think it now might be officially a suburb. I'm not sure, but it's a beautiful area. Welcome, Jenny. Did I miss anything? You have so many qualifications. It's tough to squeeze it all in. We might be out of time by now.
Thank you, Mark. I did just want to mention my office is in Chaska. I live in Victoria, but the office is in Chaska.
Okay, thank you.
Yeah, no, thank you for that introduction.
The main reason I wanted you on today, Jenny, was a core tool of estate planning that we use a lot, but it is really confusing for clients, and that is beneficiary designations. So before you tell us how you went from a criminal prosecutor to an estate planning attorney, which people are going to stick around for that. It's like putting milk at the back of the supermarket. We're going to make them walk through the healthy stuff to get there.
Sure.
Tell us, if I was a new client, if we were a new client who knew nothing about estate planning, beneficiary designations, what are beneficiary designations? What do we need to know?
Yes. So before we talk about beneficiary designations, I just want to touch very briefly on what is probate versus non-probate, because it comes down to how your assets are titled, and that's what ties into the beneficiary designation. Probate assets are assets that are just in an individual's name without a joint owner or without a beneficiary designation. So non-probate assets are assets that, for example, a married couple own jointly, or they are assets that have a beneficiary designation. So that's why when we're talking about beneficiary designations, it is so important. It is critical because it ties into your overall estate plan and what you end up with as far as probate versus non-probate type assets. And often people don't understand that. They think if they have a will or a trust, that takes care of everything and they don't need to worry about the beneficiary designations, which is not true, right?
Absolutely. We've had clients do the same thing. So I thank you for that. So it's a matter of, do you want something to go through probate or do you want to not go through probate? And I think I want to get to the meat of per capita, per stirpes, all these other issues. It's something that really bothers me. But why should people be avoiding probate, why don't you tell us what probate is real quick?
Well, probate is the court process that you have to go through, your loved ones have to go through to collect your assets. just briefly, it's very time consuming. It takes 9 to 16 months and it's very expensive. And so by making sure that your beneficiary designations are updated and current and reflective of your wishes, that's how you avoid probate. And that's why it's so important to make sure that your beneficiary designations are exactly the way you want them to be.
Perfect. Very descriptive. I think we both
Yeah.
know of a famous person in our area that did not have, that had to go through probate. Prince?
Yes. Yep.
Absolutely.
Yeah, it's crazy. Yeah. So you want to avoid probate. And that's where, to your point, beneficiary designations are so important. And it's something that clients don't often understand what they're doing when they're filling out these forms.
And I will say it's something where we spend a lot of time sending out reminders, trying to get them engaged. It's something that's so easy to put off that as a financial planner who knows what it's like, I'm sure you could share some stories with us. The repercussions for the families can be pretty devastating. As an advisor, we often get a lot of pushback. As I mentioned, it's tough for us to often get clients to do some of these estate planning things, even though they are so critical for so many reasons. How long does your process take? What can clients expect? Is it easier than many people think to really get their estate plan and their loved ones taken care of, to get them in a healthy and wealthy place?
Absolutely. We recognize that estate planning is something hard. It is something people put off. They don't want to do it, but they know they have to do it. So I think one of my jobs is to make sure it's as easy as possible for our clients to get their estate plan in place. That's why we have a very specific system and process in place that allows our clients to get their holistic estate plan in place within about 4 to 6 weeks. It starts with the life and legacy planning session. And then generally clients are coming back about 3 to 4 weeks after that to sign their documents. And then 2 weeks after that, they come back one more time for our binder delivery and wrap up. So we, like I said, a very streamlined process. We want to make this as easy as possible for clients because our goal is to get them across the finish line and create that life and legacy plan so that they and their families have the peace of mind of knowing that everything is taken care of.
Oh, well, that's not long. And I think so do clients who have actually done the full plans with us know it takes a lot longer for us to do that. So 6 weeks, that sounds like there's really no excuse. There's no excuse not to get the professional help and to go through that. I hope those that are listening realize that this is certainly something that is very doable. It sounds like your process makes it as easy as it can be.
Yes, absolutely. They get that questionnaire filled out. Like I said, the first meeting is about an hour and a half. And so that is our most lengthy, in-depth meeting because we really do want to make sure that we are creating a plan that achieves our clients' goals and values and objectives. Estate planning is not cookie cutter, one size fits all. So that's where that life and legacy planning session comes in. And then clients will come back in about 4 weeks to review all of their documents, signed, and then one more meeting to follow up to make sure that they understand what their next steps are.
Wow. Yeah, that sounds wonderful. I think my sons spend more time on prize picks than it would for them to put together, or fancy football to get rather than to get an estate plan put together.
Yeah, absolutely.
Before we move on to the types of designations, also, what else? Is there a difference between states? Is Minnesota a little less easier and costly than other states? What experience do you have around that?
Yep, absolutely. Probate's going to differ from state to state. And for example, in California, it's even more lengthy than it is here. And the way they handle it is very different in California versus the way it is here in Minnesota. But nonetheless, it's a court process anywhere you go in the country that takes time and expense.
Which is, do you want to put your loved ones through that?
Exactly.
Okay.
Exactly.
So you sold me on, I'm a new client who doesn't know anything. You sold me on having the beneficiary designations. What types of designations are they? How do they work? What do I need to know?
Yep, exactly. So if we're talking about beneficiary designations, you have a couple of different options. You have per stirpes, you have per capita at each generation. Those are the two primary designations that we talk to clients about. And really, it comes down to how do you want to treat your grandchildren? Do you want to treat your grandchildren equally, or are you okay with them being treated unequally? So the easiest way to describe beneficiary designations and the difference between the two is to start with, we have somebody who's passed away, right? Dad has 3 children. Okay, let's call them Peter, Paul, and Mary. And right, do you like that? That's
Yes, I
super
did.
creative, right?
I did. I think you have to be a Gen X or older to understand that one. So I don't think we get too many millennials or Gen Z on here, but Google it, Chat GPT it. But yes, I did like that. That's good.
Right. So per stirpes, let's say we've got Peter, Paul, and Mary, and maybe Peter has 3 kids, Paul has 2, Mary has 1. So if a client fills out their beneficiary designation and they say Peter, Paul, and Mary per stirpes, and they don't do anything else, and then the dad or the grantor or whomever is designating passes away. Now we have Mary getting her third. We have Paul getting his third. Peter's passed away, and Peter has 3 kids. Okay? So now when dad passes away, Mary gets her third, Paul gets his third, and Peter's 3 kids share his 1/3. That's what per stirpes means.
Do you find that that's what most people want?
Yes,
Okay.
I do actually, but I think that varies across the country. I also think it's very, very important to describe that to your clients. Map it out, show them a picture. This is what it looks like, because once they see it, they might change their minds.
Do you find the visualization like a little, I don't even know sure what they call it, the little boxes and the, and we're gonna flash one up on the screen here. We'll show you what that looks like. So
Fantastic.
so we had Peter, Paul, and Mary, and then it's a matter of that third is split to the decedents it's by the branch to the decedents of
Right.
the person that has passed.
Right.
What if
So-
two? Sorry, go ahead.
I was just going to say, the legal definition of per stirpes is shares determined by number of living children and deceased children with descendants.
Wow. That's why I did not go to law school. That's a lot.
Right?
I'm going to have to think about
That's why you need the diagram. You've got Peter, Paul, and Mary, and everybody's going to get a third. And if a child passes away, whether they have 1 child or 6, they're going to share just in that 1/3.
And how does per capita look different than per stirpes in your 1970s folk music example?
So with per capita, now we're going to make sure that all of the grandchildren are treated equally. Okay? So again, legal definition of per capita. Shares determined by number of descendants at each level. So again, if we have Peter, Paul, and Mary,
Okay.
right, and we have Peter who dies, and remember, Peter has 3 kids. So at this stage, it looks very similar or the same to per stirpes, but for different reasons. We have to make sure that everybody is receiving their share at that same level.
Is there ever a case where per capita and per stirpes would ever look the same?
Yes. So if we are talking about Peter, Paul, and Mary, and Peter, remember, has 3 kids. So Peter passes away, and so Mary gets her third, right? Paul gets his third, and then Peter, because he has 3 kids, his 3 kids get 1/9.
Okay.
So in that scenario, it looks the same as per stirpes. But it looks the same as per stirpes just because in this example, Peter has 3 kids.
I'm going to throw even more complexity because this happens all the time. What if two of the Peter, Paul, and Mary folk band trio pass?
Exactly.
What does that look like? Say one of them passes but doesn't have kids, and you have one remaining one, and then one of them passed that does have kids.
So if we're talking about per stirpes, right, we've still got the thirds. But if one of the children doesn't have children of their own, then that third circles back up to the surviving sibling.
Oh, okay. And so,
If there's, depending on how many have died, right?
so if there, so
Go
if
ahead.
two have passed, but only one have kids, that third goes to the remaining sibling.
It's going to split.
Okay. And we'll put that up there as well.
Yeah, so if we're talking about per stirpes, let's say we've got Peter, Paul, and Mary, and Peter has died, and let's say Paul doesn't have kids, and Mary is still alive, right? And if we're talking per stirpes, Mary's going to get her third. Peter's 3 kids are going to split his third. And then Paul, who doesn't have children, his 1/3 is going to circle back between and be divided between Mary and Peter's deceased children.
Evenly. So split up the third, one goes to the remaining child, and the other two, and the rest to the grandkids. Does that sound accurate?
Yes. And if we're talking about per capita, that's different. So if it's per capita, Mary's going to get her third. And then in this case, let's say Paul has 3 kids or 2 kids, and Peter has his 3, right? So there's 4 grandchildren essentially in this example. Now, Mary's still going to get her third, but Peter and Paul's children are going to share equally in that other 2/3 and
Okay.
get 1/6 each. Because remember, per capita, we're making sure that we're treating each generational level the same.
So if you were the simplest tagline, and I think it's difficult to make this simple, and this is why they need an estate planning attorney, is per capita treats each generation the same. Is that right?
Yeah.
And what does per stirpes do differently if you were trying to just make it really simple?
Per stirpes just cares about how many children and deceased children there are.
Okay. I appreciate that, Jenny. We still have time. We got my pet peeve out of the way, which is beneficiary designations, my core sore spot. Tell us a little bit. I'd like to circle back to your firm. Tell us about your firm. How did you get started in here? And of course, we're all wondering, how did you go from a criminal prosecutor to an estate planning attorney?
Right? Yes. Well, let's see. So I did. I went to law school to be a prosecutor. It was my dream job. It was everything I wanted it to be until it wasn't. And, I just really got to a point in my career where I was ready to do something different. I wasn't sure what that looked like. I actually considered practicing law altogether. And
Wow.
then I know it made my husband very nervous.
Well, that's a lot of work, and even even with scholarships, there had to be some debt
Yes.
involved there.
Yes. And so that was 2015. And then unfortunately in November of that year, my dad had a stroke. And I am part of a blended family. So I have 3 half siblings and a sweet little old stepmom. And they didn't have their ducks in a row. So at our office, you hear us talk consistently and continually about getting your ducks in a row. And my dad and stepmom did not have their ducks in a row. And so unfortunately, we spent some time arguing as a family about his medical care and treatment following his stroke, because we all thought we knew what was best and we didn't all agree. And then unfortunately, he passed away. And, quite frankly, we argued some more.
Oh, no.
And that's how families are, right? But it really came down to, they had wills, so I knew they'd seen a lawyer. But my dad didn't have a health care directive. And even beyond that, they, as a married couple, had not had any conversations with each other about their wishes. And so it left our family in a really, really difficult spot when we are already dealing with the grief of losing somebody that we love. And so that really got me to thinking that there had to be a better way, that families shouldn't end up in the position that my own family did. And so that's what led me to estate planning.
Wow.
I decided I was going to do it differently.
Oh, it's amazing that. Sorry for your loss.
Thank
I
you.
have to ask, were there permanent damages to your relationships with your family over the
Yep, good question. So not for me personally, but two of my siblings are not speaking to each other to this day, and it was 9 years in November.
Wow, that's heartbreaking. And
Hmm.
I think those of you listening could see where, correct me if I'm wrong, I'm guessing if there had even just been conversations, just nothing,
Yes,
we always take the view, don't let the perfect be the enemy of the good, but I'm guessing just a little bit of planning and conversations. Do you think it probably would have maybe saved a relationship?
absolutely, absolutely. And I can't stress enough, beneficiary designations, very, very important. Healthcare directives, very important. I really, I really, it's kind of my soapbox, right? Yours is beneficiary designations, mine's healthcare directives.
Yep, absolutely. No, the more I do, obviously the finance piece, the CFA nerd in me is always on top of mind. But this is part of the reason why we started this channel. We try to do focus on more than just the finances, and
Yeah.
hearing your healthcare directive. And in Minnesota, can you tell us a little bit? What do they have? Is there a standard healthcare directive? Is it healthcare power of attorney? What does that look like?
Yeah, so good question. So years ago, we used to have in Minnesota, it was called a medical power of attorney and a living will. And you will hear those terms used throughout the country because many states still use medical power of attorney and living will. In Minnesota, we really combined those documents, and now we call it a healthcare directive, but it has two parts to it. The first part is who's your agent going to be? And that's essentially your medical power of attorney. We just call it a healthcare agent now. Who's going to step in and make healthcare decisions for you if you can't make them for yourself? And then part two of your healthcare directive is your healthcare instructions. And those are really what are your wishes. And so we help our clients fill those documents out to make sure that their wishes are known, as far as what they want for their medical care. Do they want to be buried or cremated? Do they want to be an organ and tissue donor? These are all really important decisions to make, and you should get to make those for yourself, not leaving that to somebody else to make for you.
Well, leave them guessing. And this is where I could see where this is where having someone who does that's all they do is so powerful. Again, the finance piece aside,
Yeah.
having someone who knows what possible outcomes might be and how to fill out these forms, I could see where that would be a huge advantage.
Yes. So, I mean, that kind of dovetails into why people shouldn't do it themselves, right? Having the legal advice and the legal counsel to help you make those decisions, completing your documents, making sure you really truly understand the outcomes that you're creating. Just even going back to the beneficiary designation, somebody fills it out themselves. And if the custodial documents are saying per capita, they think, great, that's great, but that might not really be what they want. And so without somebody who has the professional background to describe what those things mean and what the outcome looks like, it's really, they're doing a disadvantage to their family if they try to do it themselves.
And it seems like it comes down to you don't know what you don't know, and if you're trying to do this yourself, especially if you're not spending much time on it, it seems like you, your probability of success, I would imagine, is greatly decreased if you're doing this yourself and especially not spending time on it.
Yes, absolutely. And you're costing your family a lot of money and time and conflict and emotion by not um, taking the time to really sit down and do it right.
Yeah, absolutely. And I think for some families, I would imagine they want to leave a legacy of not just money, but a legacy of a healthy family. And it sounds like unless you spend some time putting this together, there's a chance that that might not happen.
Absolutely. That's why at our firm, we really focus not just on estate planning, but on life and legacy planning. So it goes way beyond just preparing a will or a trust, but really doing everything we can to make sure that our clients' plans work for them when the time comes. So, that's things like ongoing guidance on what your documents mean and how they work together. We help them provide instructions to their family so their family will know exactly what to do when the time comes. Updated asset inventories are so important because of the number of lost assets. If your family doesn't have a list of your assets that's current, they're likely to miss something. They may not know you have a 401k here or an IRA there or life insurance with a particular company. And so then your assets get lost and they don't end up into the hands of the beneficiaries. So updating your assets is so important.
Wow. So if no one knows it's there, it could just be lost forever. Is that right?
Absolutely. In Minnesota, the Minnesota Department of Commerce holds unclaimed property. So you can actually go to the website and plug in your name or the name of a loved one to see if you have any assets that haven't been claimed.
Yeah, I tell you what, we'll put that in the show notes as well. Wow, great tip. That could save someone thousands and thousands of dollars.
Yes.
Thank you, Jenny. A lot of really, really good information. I mean, some of the stuff was eye-opening, and thank you for sharing your story. If folks want to reach out to you and get their estate plan in a healthy and wealthy spot, so they leave their family as good a spot as when they left, how do they get in touch with you?
Yes, so you can go to my website, spaldinglawoffice.com, and certainly schedule a 20-minute call there. Otherwise, you can call our office directly if you're ready to get started. Our process always starts with what we call a life and legacy planning session. And so in advance of that session, we send you a link to a questionnaire to complete so that we have as much information as we can gather. Then we get together for that session, and we really spend the first half focusing on education, making sure you truly understand what your options are. We talk about the difference between wills and trusts, powers of attorney. We talk about your healthcare directives. We talk about how beneficiary designation forms and assets that are governed by beneficiaries tie into your overall estate plan. And then we can really spend the last half of the meeting actually designing a plan that achieves your goals, objectives, values, and what your wishes are. So you can either go to the website to schedule a call, or you can call our office directly at 952-486-8855. And if you have any questions, you are welcome to reach out to me directly, Jennifer at spaldinglawoffice.com.
And we will have all that in the show notes. It sounds like you really do take a holistic approach, which I guess, Mike, with financial planning, you really do need if folks are going to have a healthy and wealthy estate plan. Anything else you'd like to leave us with?
I would like to share that we are offering all of your listeners a discount on our services. We have 3 different planning levels. And so the life and legacy planning session I mentioned is complimentary as long as clients or potential clients agree to fill out the questionnaire ahead of time.
Wow.
But then we'd like to offer your listeners $250 if they decide to move forward and work with us.
Wow, amazing. Very great. So reach out. I think you won't regret it. A little bit of planning now is going to give you peace of mind while you're still alive, but also give your family certainly a better experience and certainly making your wishes known. So thank you for joining us. We appreciate you here. As you can tell, if you follow some of Jenny's tips, you're going to have a healthier, a wealthier, and a happier retirement. Don't forget to hit subscribe.
Thank you, Mark.
Thank you. Thanks for tuning in. If you enjoyed this episode, make sure to hit subscribe, leave a review, and share with your friends. Share the love. Make sure they have a healthier, a wealthier, and a happier retirement as well. Also, don't forget to subscribe to our newsletter for free resources and check out our website and social media pages for exclusive content and updates. See you next time.
Sona Financial, LLC, DBA Sona Wealth and Sona Wealth Advisors is a registered investment advisor with the state of Minnesota. All views, expressions, and opinions included in this communication are subject to change. This communication is not intended as an offer or solicitation to buy, hold, or sell any financial instrument or investment advisory services. Any information provided has been obtained from sources considered reliable, but we do not guarantee the accuracy or completeness of any description of securities, markets, or developments mentioned.